Here I am. Here we are. Yes. Another video. I want to talk about what happens after somebody gets arrested. I'll give you two examples because it really depends on whether or not someone is arrested for a misdemeanor versus a felony. Meet Alex. Alex is 22, and let's say he was just arrested for a DUI here in Colorado. Alex will get arrested, he'll get booked into jail. Some jails already have pre-established bonds, so if he can pay a bond, he can leave, and then he's released on his own recognizance. That means just a pinky promise that he'll come back to court, and then he will likely have to appear in the county court for a first appearance and an arraignment. And so during a first appearance and an arraignment, there's basically a few things that happen. The judge is going to advise Alex of the charges and his rights as a criminal defendant. Will give an opportunity for Alex to enter a plea, whether he's guilty or not guilty. And the judge is going to set bond conditions, things like no alcohol use. It might have an ignition interlock. Because it is a misdemeanor, the arraignment and oftentimes the first appearance happen at the same time. They don't have to go through a grand jury. There's no preliminary hearing. From there may be a pretrial conference where the prosecutor offers a plea deal. If Alex maintains his innocence, it's going to go to a trial. Generally, there's some hearings about what types of evidence can come in and out of the trial. The trial will happen. Alex's guilt will either be determined by a judge and or a jury of his peers. Let's say that Alex was arrested for a felony. Let's say possession of a bunch of fentanyl. That would be a felony. Let's say it's a possession of fentanyl with intent to distribute. That would be a third-degree felony here in Colorado. Definitely no bueno. That's a problem. Felonies, no joke. So let's walk through the process as if Alex was arrested for this felony, because with a felony, things slow down and the process gets a lot more formal because of the seriousness of the charges. So same thing, Alex gets arrested. He's going to be booked into the county jail where he will be fingerprinted. He's going to have his photograph taken, and not a photo you want to be smiling in. They're going to ask him medical questions such as, does he have any life-threatening illnesses or diseases? Is he in a gang? Does he want to kill himself? Because once you are in custody, you become a ward of the state. They want to make sure that you stay safe and healthy while you are in prison. And then likely he will get booked into the jail since it is a felony. And so Colorado law says that defendants must appear before a judge within 48 hours of them getting into jail. And there's a fork in the road because for minor offenses, offenders may leave on their own recognizance, meaning that they are released with a promise that they're going to show up. It's basically like the criminal justice version of, I peaky swear I'll come back. But for serious felonies, Alex is usually going to be in jail until a judge is able to review the case. Once officers make the arrest, they write the report and then they forward it to the prosecutor. So the prosecutor is the HBIC. They are the ones that determine what charges to file, if at all. So they're going to look at all the evidence to determine whether or not a crime has been committed and if a specific person committed a crime. If they believe so, prosecutors are going to file the charges. And so they do this in a couple different ways. And so with a felony, they're going to write up a complaint. This is basically a legal memo that says, here's what we think you did, and here's why we're mad about it. Because it's a felony, Alex has the right to what we call a preliminary hearing unless the district attorney decides to go to a grand jury instead. Preliminary hearing. Prosecutor is really just focused on establishing whether or not there's enough evidence for probable cause to show that a crime was committed and that the defendant is the one that committed that crime. The prosecutor is going to go through the case. They don't have to present their whole case. They're presenting to a judge, and they are just trying to convince a judge that, hey, there's enough evidence in this case to establish probable cause. In other words, this is the case that's going to be worth the time and resources to prosecute it. Here's what we have. The defense can be there. They can cross-examine witnesses, but generally it's the prosecutor's show, and all they need to do is just establish probable cause. And so it's up to a judge to determine whether or not there is enough evidence in a case to establish probable cause for it to move forward. Now, let's say that Alex was arrested for possession of fentanyl, and he's part of an organized crime ring. And so the case is much more complex. In that situation, the prosecutor may go towards what we call a grand jury. And so a grand jury is a tool for prosecutors to help basically get a general consensus from the public of a jury of their peers as to whether or not they think that there's enough evidence to establish probable cause in the case. Grand juries are convened very similar as to how juries are for a criminal trial, but this happens before a criminal trial. And they are generally larger and they are much more secret. They are closed off to the public. The defense does not show up. It is essentially an opportunity for prosecutors to run their case across a large pool of citizens from the community to get their sense of whether or not there's enough probable cause. And so this is generally done for more complex cases. They're going to present it to the grand jury. If the grand jury believes that there is enough probable cause, they are going to issue an indictment. Overall, both a preliminary hearing and a grand jury, their sole purpose is to determine whether or not there is enough probable cause in a case to believe that a crime was committed. So for a preliminary hearing, the judge is the one that determines whether or not there is probable cause. In a grand jury, it is the jury that is determining whether or not there is probable cause in the case. So during arraignment, there are three important things that happen. The first is that the court is actually going to read the charges that Alex is being charged with. So it's a formal reading of the charges. Sometimes this is where the defendant is actually finding out exactly what they are being charged with. And so the judge or the court will read the complaint out loud. This basically informs the person of all the charges that they are being charged with. And for each of those charges, the defendant is then offered the second important thing that happens in an arraignment, which is their ability to enter a plea. And so at this point, the defendant can say, yep, I'm absolutely guilty of these charges. They can also plead no contest or nolo contendere. This essentially means that I am not pleading guilty, but I recognize that the prosecution or the state has enough evidence to convict me should this go to trial. So it's essentially like a guilty plea. And so oftentimes a no contest plea is a strategic way to avoid issues in a civil trial. So remember that somebody can both be charged in a criminal case and also have to go through a civil trial. They're separate courts dealing with different things. So suppose Alex crashed into another driver while transporting the drugs. Pleading guilty could be used against him later in a civil case. A no contest plea still resolves the criminal case, but it can't be used to prove liability in a civil case. And so oftentimes when people are pleading no contest, that means they are doing so strategically so that they can't be sued in civil court, regardless of the outcome of the criminal case. So during the arraignment, formal charges are read. The defendant is able to enter a plea, guilty, not guilty, or no contest. And then the third aspect of the arraignment is for the judge to establish bail. So at this point, the person is generally held in jail, and the judge determines bail and decides whether or not Alex should stay in custody, be released on their own recognizance, or establish bond and allow Alex to post that bond. If someone pleads guilty or no contest, the court moves straight to sentencing. Sometimes there can be confusion with the order of events in criminal cases, to the point that the preliminary hearing and arraignment sometimes seem to be flipped around, especially in felony cases in Colorado. So remember that all criminal cases start in a county court, even felonies. That's because the county court handles the early stages like setting bond and advising the defendant of their rights before the case moves up to district court. Within 48 hours of arrest, the person has what's called their first and second appearance. And so during these appearances, this is where the judge is going to explain the person's constitutional rights. They're trying to see if the person has their own lawyer, and if they can't afford one, then they are appointed a public defender. And this is where the initial charges are read based on the prosecutor's early review of the case. So at this point, the charges are still preliminary. The prosecutor hasn't filed the formal official charges yet. That happens later once there's a determination that there's enough evidence to move forward. For felony cases, the next key step is the preliminary hearing. This is where a county court judge reviews the evidence and decides whether there is probable cause to believe a crime was committed and that the defendant probably did it. If the judge agrees that there's enough probable cause, the case is bound over or transferred to the district court. Once in district court, the prosecutor can then file the formal charges, and that's when the arraignment happens. And during the arraignment, this is where the defendant hears the official charges on the record and are allowed to enter a plea. Now, in some cases, instead of holding a preliminary hearing, the prosecutor might take the case to a grand jury, especially for complex or high-profile cases. The grand jury decides if there's probable cause to issue an indictment, and if they do, the case moves straight to district court for the arraignment, just the same way. So in short, everyone gets their first and second appearance in a county court within 48 hours of arrest. Misdemeanors usually stay in the county court all the way through trial. Felonies start in county court but move to district court once probable cause is established, either through a preliminary hearing or a grand jury. Only after that does the arraignment happen in district court, because that's when the official charges are read. That's why it can feel like the order flips, but really it's just about which court has jurisdiction and when the prosecutor is legally allowed to file formal charges. If they plead not guilty, the case proceeds to the next stage, which will be pretrial conferences and hearings. Okay, so let's say that Alex pleads not guilty to his massive possession of fentanyl. So at this point, they've gone through the preliminary hearing. The judge issues a surety bond, and Alex is unable to pay, and so he's going to sit in jail until it is time for trial. So during that time, the prosecution is going to work with the defense involving a process called discovery. Discovery is like the legal version of show me your cards. So the prosecution must hand over all evidence that might be relevant, especially anything favorable to Alex. And this is called exculpatory evidence. Hiding evidence that could exculpate a client is known as a Brady violation. This is a huge issue. It basically says that the prosecution was withholding evidence that could convince a jury that there is reasonable doubt in a case. And so if prosecutors are withholding evidence, the defense can motion for a Brady violation. And if a judge agrees that the prosecution withheld evidence, it could result in a mistrial, and even the prosecutors could end up getting disbarred. So it is a very serious process. And it's also a fair process because oftentimes the prosecution has a lot more resources than the public defender's office or defense. And so because they have the powerful resources of their own police department, their own investigators, they have to turn over any evidence that could point to reasonable doubt in a case. And vice versa, the defense also has to turn over any reports from expert witnesses, witnesses lists, and any alibi information, so the prosecution can also vet the information. Here's an example. Let's say prosecutors give Alex's attorney, lab results, body cam footage, and phone record data. The defense shares a chemist report suggesting the powder wasn't fentanyl. If either side hides evidence, the judge can issue sanctions or dismiss parts of the case, or even the case could result in a mistrial and the prosecution and or defense could be disbarred. So discovery is a very key process that allows for each side to share that information in ways that ensure the defendant has a due process right to a fair trial. Additionally, during this process, there are also a series of pretrial motions. These motions essentially shape what types of evidence can be admitted into court. And so we have things like motion to suppress, motion in limine, and there's also motions for a change of venue. Let's say Alex is a high-profile celebrity, real well known on TikTok, tons of followers. Everyone in Colorado Springs knows him. And so in order to have a trial here in Colorado Springs, it might be unfair, especially if he is really hated or really loved by a lot of people. So oftentimes, if the defense argues that this person is well known or there's too much bias in the community, it's a very horrific crime or high profile crime, the defense can argue that the defendant is not going to get a fair trial, and so they can file a motion to change venue, and this ensure that the person can be tried in another jurisdiction like Fort Collins or Denver, where less people may know who Alex is and are more impartial, or there's a larger population of people that can be more impartial because they have no ties to the case. More importantly, from what we learned from things like the fruit of the poisonous tree and the exclusionary rule, there are also motions to suppress. And so this is essentially arguing that evidence should not be admitted into trial because it was searched and seized illegally, violating the Fourth Amendment. And so this is essentially asking the judge to throw out evidence because police broke the rules. So, for example, the defense attorney can argue that the fentanyl should be suppressed because the search was illegal. And we also have motions in limine, and this essentially argues other types of evidence that can and cannot come in. So it determines which types of evidence can be discussed in court. People aren't convicted because they're an asshole online. They're convicted due to evidence beyond a reasonable doubt. So evidence like Alex's social media posts about, living a hustler's lifestyle may be argued to be not admissible in court because the statements are going to be much more prejudicial than actually probative to what the state is trying to prove. And so the state may try to argue to get all this information in to show that it's a pattern of behavior, but the judge essentially has to determine whether or not the evidence is relevant to possession of fentanyl versus living a hustler lifestyle. And so a motion in limine essentially just limits what can be brought up in court and what the prosecution and defense can ask witnesses. In sum, the pretrial process really depends on whether someone is arrested for a misdemeanor or a felony. Misdemeanor cases generally move a little bit quicker. Felonies take time because of the seriousness of the crime. Also important to know that throughout this entire process, prosecutors may offer a plea deal. And so plea deals can be offered at any time, and it is up to the state to determine whether or not they are going to offer a plea deal. Sometimes the defense can request a plea deal and the prosecution and defense can work something out. But generally, this is the process of what happens after someone is arrested. Next up, we'll talk about the courtroom work group. Who are the prosecutors? What does the defense do? Who's the bailiff? And why does Judge Judy keep screaming at him? Until next time.